Hello, everyone, and welcome to this Federalist Society virtual event. My name is Marco J. Lloyd, and I'm Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host a litigation update on Miller v. McDonald featuring Bob Overing. Bob is a deputy solicitor in Alabama's Solicitor General Division and an adjunct professor at Faulkner Law School. He clerked in the Ninth Circuit Court of Appeals and served as counsel to the U.S. Senate Judiciary Committee. He received his law degree from Yale Law School. Our moderator today is Judge Sean Jordan. Judge Jordan is a judge in the United States District Court for the Eastern District of Texas. Before this, he was a partner at Jackson Walker LLP, where he was co-chair of the firm's appellate practice group. Prior to entering private practice, he served as Principal Deputy Solicitor General for the state of Texas. He also served in the United States Army as an infantryman and paratrooper in the 82nd Airborne Division. If you'd like to learn more about today's speakers, their full bios can be viewed on our website, fedsoc.org. If you have a question at any point in today's program, please enter into the Q&A function at the bottom of your Zoom window. We will do our best to answer as many as we can. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speakers. With that, Your Honor, thank you for joining us today, and the floor is yours.
Thank you. Good afternoon, everyone, and welcome to this litigation update on Miller v. McDonald. This is a case coming out of the Second Circuit with a cert petition now pending at the Supreme Court. It's an interesting free exercise clause case involving a New York statute on vaccination of school children. At issue in the case is a relatively recent change in New York, its applicable vaccination law. For over half a century, dating back to the 1960s, New York allowed both medical and religious exemptions to its school vaccine requirement. That changed in 2019 when the New York legislature eliminated the religious exemption. This case arises from that change in New York law, and particularly its application to the Amish community. The plaintiffs, who are comprised of Amish schools and parents, have challenged the validity of the New York law as applied to them under the free exercise clause. There's also a so-called hybrid rights claim under Wisconsin versus Yoder, which we'll also talk about today. And for this discussion, as Marco mentioned, we're most fortunate to have Bob Overing, the Deputy Solicitor General in Alabama's SG office. Bob has participated in this case at both the Second Circuit and the Supreme Court stages of litigation, as Alabama has led a coalition of states that have filed amicus briefs on the issues that are before the court. So, Bob, I'd like to begin our discussion with you helping us understand the background of the case a bit better. Can you tell us about the New York law at issue and similar laws in other states?
Right. Well, thanks and good afternoon, Your Honor. Depends how far back you want to go, right? So we have school immunization requirements in every state in the country. Students have to receive a list of vaccines to attend school, and many of those requirements date back to the 1800s. But similarly longstanding is the practice of allowing religious exemptions and objections to those requirements. At least for decades, virtually all states have had religious exemptions, including New York. And the Amish community in New York and probably elsewhere takes advantage of the opportunity to opt out from that regime, and they have multiple reasons for that. They are people who put their trust in God, not so much in modern medicine, and they also object because of the way that some of the vaccines were developed using cell lines from aborted babies. Now, they've been this way for centuries, for decades, and their practice hasn't changed, but New York's has. So in 2019, New York amended its law to remove religious exemptions. Apparently, California had done so in 2015, so I think New York is the second state, and now so have Maine and Connecticut. So we have 4 states who have removed religious exemptions from the school immunization requirements, and 46 states that provide some form of religious exemptions, including Alabama. And I should say that we're participating as amicus, and I'm happy to talk about our arguments, but what I say today is in my personal capacity, not representing the state.
All right, thanks, Bob. And we're definitely going to talk to you about Alabama's briefing in this. I want to ask you a little bit, get a little bit more granular on this New York law. This changed in 2019. Now, my understanding is it's a law that applies to both public and private schools, and that the penalties for violations of this law are can be pretty steep. Thousands of dollars in civil penalties per violation. Maybe you can talk a little bit about those specifics of the law, and then we'll get into this application to the Amish here.
That's right. So the penalties, at least the way New York has interpreted them, and I'm not sure if that's on the face of the statute or by regulation, but it's $2,000 per student per school day. So if you had 100 students, $200,000 per school day could easily add up to millions in penalties every school year. And as you can imagine, these are not huge schools that we're talking about in rural Amish country, and yet they would be facing millions of dollars in potential penalties. And the other important feature of the law, critical for the petitioner's case here, is that it does provide for medical or health exemptions. And the way that works is that any student who can get a doctor's note from any physician licensed in New York who certifies that the immunization may be detrimental to a child's health. And that's pretty much all we know. They've issued more guidance, the state has, and then New York City and the public schools have issued more guidance because they've had a lot of problems with the arbitrary and varying application of the medical exemption. But the face of the statute just says detrimental to a child's health. And so you've got this sizable or vague carve out for medical exemptions and none at all for religious exemptions.
Yeah, we're gonna get into that as we delve into the issues, but that's very helpful background on how this law operates. Now, we've talked about how this change in New York law came in 2019, but I understand that this case arises a few years later in 2022 when New York authorities initiated enforcement action against these certain Amish schools, which again, I understand are private schools in Amish communities in rural New York State. And so can you give us a bit of the background of this enforcement action that winds up leading to the filing of this case?
Right. So there's sort of a lull between the time when the law is enacted and then this administrative action is brought against the Amish communities. I think there's some evidence in the record that the New York legislators had religious communities like these in mind when it repealed the exemption. And yet it took about 2 years, which I think the petitioners can credibly say undermines the state's proffered interest. About sometime after maybe 2 years, the Department of Health gives them a notice that says, we think you're out of compliance, and audits their records. Of course, they don't have vaccine records as far as I know, because they don't believe in the practice. They don't use them. And so then they have to go through the administrative law proceeding in the Department of Health, and the ALJ found that indeed they had violated the school immunization mandate, but recommended no penalties, basically saying, look, it would be unfair because they're just hearing about this now, and they didn't know that. I think they may not have known that the repeal had even taken place, but the Department of Health agreed that they had violated the law and then sustained penalties, which in this case, or in their case, totaled $118,000, which in the state's view was very generous that they actually said that. And in some sense, that's true, because they could have issued potentially millions or tens of millions of dollars in penalties to these schools, which they could not afford. And so you get this lawsuit in June of 2023. to resist the penalties and enforcement of them in the future. And they're basically driven here. I mean, my feeling from reading the materials is that these are very reluctant plaintiffs, that these are not people who want to be litigating, who want to be suing the state, but have been driven here because they view it as having no choice.
That brings up a good point. Bob, these schools, by the way, in terms of these penalties, my understanding is these are all pretty small schools. They don't have a large number of students in them. They're in these Amish communities, and my understanding is the entire Amish population in New York is around 21,000. And but I want to talk a little bit before we get into the specifics of this suit. You just were referencing that the plaintiffs are reluctant, and it may be a good point to talk a bit about these Amish schools and the community that's at the center of this litigation. Over 50 years ago in Wisconsin versus Yoder, the Supreme Court observed that the Amish share, and I'm quoting, a fundamental belief that salvation requires life in a church community separate and apart from the world and worldly influence. And more recently, Justice Gorsuch observed in Mass versus Fillmore County that the Amish, quote, are religiously committed to living separately from the modern world. So it does seem that now, as then, the Amish do live apart from contemporary society and the trappings of the modern world, so to speak. And you've talked a few minutes ago about, religious objections to vaccination laws. Maybe you can talk a bit about, where the Amish stand on this and how we get here with this community.
Right. Well, and we do have some material in the record on this, even though it's on motion to dismiss, which I'm sure we'll get to. They're because of that administrative hearing, many representatives from the community showed up to explain kind of this is our way of life. This is why we object. These are sincere religious objections, and as you said, it's a traditional life, a life of seclusion. They use pre-industrial equipment, make their own clothes, and so this modern technology of the vaccine just doesn't fit well in their way of life. And they have a religious objection that it requires them to trust a form of science and technology that they don't believe is required or even conflicts with their trust and faith in God to protect them, to protect the health of their children. Beyond that, they have said that one of their religious beliefs is that they need to school their children, to educate them in the faith and for the socialization. Now, famously, of course, in Yoder, that is not indefinite. They do object to compulsory education until all the way until adulthood, but at least when the children are young, it's important to have them in school. And they also say that because so much of their way of life is dependent on physical manual labor, that it's just not practical to homeschool them. And so there are all of these things: compulsory education, the vaccines, modern medicine, the upbringing of children and educating, all kind of come together for, I think, a very, very credible, very sincere, and very powerful religious objection to what New York is trying to do.
And Bob, there's not been any dispute in the case that these are sincerely held religious beliefs. I mean, that's not been part of the defense, right?
No.
All right. So let's get to talking about the action that was brought initially in the Western District of New York. We have a group of Amish schools and parents that file this suit. They bring an as-applied challenge to the New York vaccination law, which I'm going to refer to sometimes as this public health law, or PHL 2164. The claim is grounded in the free exercise clause as applied to the states through the 14th Amendment. There's also this hybrid rights claim, again, under the Supreme Court's decision in Wisconsin v. Yoder. But let's start with the as-applied challenge under the free exercise clause, and let's talk a little bit about what that claim looks like. We know the free exercise clause bars the government from making any law that prohibits the free exercise of religion. And for our listeners' benefit, Bob, can you describe the free exercise claim that's being asserted, by these plaintiffs, and maybe walk through a little bit? I think we have the schools, and then we have a few individuals.
Well, of course, with the free exercise clause, we're not writing on a blank slate. Everyone knows the big touchstone of modern free exercise jurisprudence is employment division versus Smith. And so even starting with the complaint, there is a ton of analysis on Smith. And the rule from Smith has been that a government's burden on religion does not need to satisfy strict scrutiny if it is a law of neutral and general applicability. And so the complaint spends a lot of time explaining how the immunization regime is not neutral. It was targeted because it was a repeal of a religious exemption. So the law passed in 2019 was specific to religion. And then it's not generally applicable because there's this huge carve out for medical and health exemptions. And so the complaint itself argues that this claim has to be evaluated under strict scrutiny, and they say that it fails. It's not narrowly tailored because of the exemptions, because adults don't have to be vaccinated in New York, and because a lot of the immunizations don't protect other school children or other people in New York State from transmission. Many vaccines, such as tetanus and others, don't prevent transmission, and so the stated health interest is not met by the regime that is so broad in its requirements and burden on their religion. They have, of course, a lot in the complaint about their particular religious practices. The plaintiffs, I don't think we mentioned, are not just the schools, but also two parents of children at these schools and a representative of the Amish community who says, these are our beliefs, they're sincerely held, and the parents saying to do this, to shutter the schools or to put us to the choice of vaccinating or keeping our children home would work a serious burden on our religious beliefs and practices. So that's the as applied challenge. I think it could be construed as a facial challenge too, because I think a lot of a lot of religious exemptions could have the same character. Of course, there's a lot specific to the Amish in here, but I don't want it to be lost on the listeners that this is an issue of great importance across the country, not just for the Amish community.
So, Bob, I want to unpack that a little bit, and starting with the last point you were making about as applied and facial challenges. This has certainly been framed as an as applied challenge as opposed to a facial challenge, but maybe you can talk about the difference between as applied and facial challenges.
Well, and I think it doesn't come out much in the cert petition, and I don't know that it'll make a major difference to the outcome of the case, depending on what the court may be interested in doing with this case if it were to grant certiorari. But what they were trying to do, I think, is avoid this Second Circuit precedent that had come out of Connecticut. Connecticut had a similar repeal of its religious exemption law, and the plaintiffs here were in a tough spot because of that circuit precedent. And so they had to argue that there was something different. And they do have a plausible argument that they have a different kind of injury because their resistance to modern technology, modern medicine, and all that is so unique to their faith. And that was the impetus behind Yoder, or at least the conventional reading of Yoder, is that there are certain burdens that for certain faiths are so destructive that it would essentially undermine their ability to practice their religion at all. And so that's the as applied challenge.
Right, and you're coming back to Smith. You talked about how the dispute we have here, the central dispute, is whether or not, in the first instance on this free exercise claim, whether or not this law falls within Smith. It's neutral, it's generally applicable, and therefore subject to, as you mentioned, rational basis review. Just so we know, the field we're on, tell us what is that rational basis standard? What standard does the law need to meet to survive constitutional scrutiny under that standard?
Well, it is the lowest form of scrutiny. Did the state have a reason related to the burden that it imposed on the right? And courts, it's not hard for courts to find a rational basis. They can look at the face of the statute. They can look at legislative findings. They can even conceive of a rational basis from the text or structure of the statute. It's going to be very hard for plaintiffs to win under a rational basis standard. And so that's why Smith has come under such fire from, as this group, this audience knows, for many years. It's very hard to win once the court has decided that Smith is the proper test.
Right. So fair to say that so long as the court can say that the state's chosen a means for addressing a legitimate government interest rationally related to achieving the goal, it's going to be able to survive that type of scrutiny.
That's right.
And but if the law it does not fall under Smith and we don't have rational rational basis test, then we're looking at strict scrutiny, correct?
That's right.
And this is a test that is sort of at the other end of the spectrum. This is a very difficult test to me. Can you talk about the strict scrutiny standard?
Well, the state will have to show a compelling state interest, and that the means it's employed to achieve that interest are narrowly tailored. And states have not been in the habit of doing that in free exercise challenges under the First Amendment since Smith. And so if you're in the world of a Smith exception, or if Smith is reconsidered or pared back in any way, then we'll probably see a lot more successful religious liberty challenges, because it is hard to satisfy strict scrutiny. It's often said that it's fatal in fact. And I think maybe the best analogy for what that might look like is right there in the First Amendment in the free speech clause. If the government is discriminating based on the content of speech in general, they will have to overcome strict scrutiny, and most laws will fail under strict scrutiny unless they have a sufficient historical pedigree in some cases. So this is the whole ballgame for a basic free exercise claim. Does Smith apply or does it not? And the exceptions thus far, at least until the last 5 years, have been construed very narrowly. And so we're going to see in this case, will that change? And we can talk about that more when we get to the petition.
Yeah. Let's talk about that a little bit right now, just because I think it matters to understanding what the lower courts did in this case, or what they didn't do. We've talked about Smith. It's issued 35 years ago. And since that time, the courts issued decisions, as you just noted, mainly, in recent years, that clarify Smith. Some have said narrowed Smith. And the application of when strict scrutiny is going to be applied. And I'd like to talk about some of those cases with you quickly. So we have some recent Supreme Court cases like Tandon versus Newsom. We've got Fulton versus City of Philadelphia on free exercise, and then we have Mahmoud v. Taylor, which gets into the Yoder claim. But can you talk a little bit about how some of these cases have clarified Smith?
Right. So I think backing up even further, for many members of this audience, this may well be familiar, but for me coming to this case, I kind of assumed that overturning Smith was the big game that everyone needed to be focused on. And there have been so many law review articles, how to replace Smith and what should come next. Should it be strict scrutiny? Should it be a historical approach? And what we've seen in the last 5 years is that the court has been able to interpret and apply Smith in a way that seems a lot more fair to the religious plaintiffs in these cases, by really clarifying I'd say two categories of exception, and there may be more. One is that a law is not generally applicable and neutral when it relies on a system of individualized exemptions. And so when you have the government making case-by-case determinations about whether the law should apply to someone, that is not neutral. And in that circumstance, religion needs to be treated as well as the reasons that justify an exception from the law, the secular reasons. And The second category gets at what I just said a little bit more directly, which is whatever the state's secular reason is for exempting some conduct or activity from a general burden, religion has to be treated at least as favorably. And so we saw this a lot in the church shutdown cases during the virus times, where you had governments who were keeping restrictions on capacity and the types of activities that could be done in church or worship services. And yet they were keeping open or allowing to operate other businesses, secular businesses, whether it was a hair salon or a bowling alley or a movie theater, something like that. And the Supreme Court, starting in the Brooklyn Diocese case, but then really in Tandon versus Newsom, said that if you're allowing secular exemptions, you have to treat religion at least as favorably, what some have called a most favored nation approach. And this is new. This is new because it was there in Smith, it was there in Lukumi, but it hadn't really been refined into a doctrine. And so we'll see in the coming years, we'll see in this case if the court wants to continue to clarify those exceptions and make Smith more livable, more workable for really sympathetic and compelling plaintiffs like these ones.
All right, Bob, I think that's a good jumping off point to talk about the specific arguments made in this case by the plaintiffs. And I think these are arguments that were made in the district court. They've been made in the Second Circuit, and we see them in the cert petition. To begin with, I understand the plaintiffs concede that if rational basis review were applied under Smith, they would not be successful in this suit, and they believe it would be upheld. And they make essentially four arguments for why this case falls outside of Smith, and therefore New York's law would need to pass strict scrutiny. The first is that this law is not generally applicable. The second is that it's not neutral. The third is that this is the hybrid rights claim, is that this case involves the free exercise clause in conjunction with other constitutional protections, implicating Wisconsin v. Yoder or Mahmoud type of analysis. And fourth, they also have argued that this New York law is outside of Smith because, unlike the law at issue in Smith, this law is amenable to religious exemptions. And it would not be, so to speak, borrowing from Smith, courting anarchy to allow for such exemptions. And I think part of that point that's made in the briefing, including your own, is when you have 46 states that have such exemptions, that's a big indicator. I want to walk through these with you, just these arguments, just for you to put a point on them, and then we'll talk about the lower court rulings. Let's talk about those generally, why the law is not generally applicable according to the plaintiffs.
Yeah, so that's where we focused a lot of our briefing as amici, and those are kind of the two categories I just spoke on. The fact that there's a medical exemption in New York is enough to hold that it's not a generally applicable and neutral law, because the state is giving pride of place, giving special solicitude to a secular reason for objecting, while denying the same treatment for a religious group. And so it's essentially a discrimination principle. Now, New York comes back and they say, well, it's different because we have different reasons for allowing a health exemption. If there's some contraindication, then there's some harm that could come to the child from taking the vaccine. And New York cares about that. And I think petitioners have a pretty good response to that, which is, well, plaintiffs have a religious view of harm. They have a different view of harm that New York is discounting when it says that the health exemption is a type of harm we care about, but the harm to the soul of the child is one we don't care about. That's when strict scrutiny should apply. And I think under Tandon, that's a pretty good argument, and we've emphasized that in our briefs. On the hybrid rights argument, hybrid rights is one of these areas that has been somewhat of a mystery since Smith, because Smith has to deal with Yoder, which we already talked about. And what Smith says is, well, Yoder's explainable by the fact that it dealt with two rights at once, the free exercise right and the parental right to dictate and form the upbringing of one's child. And since then, the Second Circuit in a series of cases had said, this is basically a dead end. There is no viable hybrid rights claim in the Second Circuit. Now, they said all of this before the decision in Mahmoud last term, which really changes the landscape for hybrid rights. Mahmoud doesn't use the diction, the precise terminology of hybrid rights as much. It's treating the Yoder claim, the religious right to inculcate values in one's children, as an ordinary free exercise claim. You don't have to prove that you meet two different constitutional tests to invoke it. And that's really important. And then the fourth category you've spoken of is the whether the law is amenable to exemptions or whether it's the kind of thing that would cause anarchy. I could see that coming into play, but we don't have quite as much doctrine on that one.
All right, let's talk about the decisions from the lower courts and starting with the district court. I think the district court, was faced with a request for a preliminary injunction from the plaintiffs and a motion to dismiss under Rule 12b-6 from New York, and it wound up granting the motion to dismiss and therefore denying the PI request as moot in this case. And it looks, and the district court's decision was very much driven by the court feeling bound by the Second Circuit decision you mentioned earlier, the We the Patriots case that I think concerned, another, vaccine case. And so is that your read of the district court opinion that basically We the Patriots resolves this issue, it's binding Second Circuit precedent, and that's why this claim fails?
Yeah, that's right. And I think the court comes up with some new rationales, the idea that well, maybe religious exemptions in some way are more dangerous to the state's interest than secular exemptions, because you could have lots of people together congregating who are not vaccinated. And I just think petitioners have a pretty good response to that, that if you look at the individual's religious objection, the damage, the harm to the state's interest is equal, whether the student is not vaccinated for religious reasons or medical reasons. If the state's interest is promoting the most amount of vaccination, then these two types of objections undermine the state interest in the same way. So with that wrinkle, I don't think there was much new for the court to say, and so it goes up to the Second Circuit, and the Amish make the same arguments that we've discussed, I think, in of course, greater detail than they could in their complaint. And there's oral argument, and the court was pretty skeptical of oral argument, I think, because we've had Smith for so long. So you have 30 years of looking at a law like this and saying, well, it's pretty general, the state's going to win. And of course, that's what the Second Circuit ends up saying. They say that.
I'm sorry, I was going to say, let's talk about that Second Circuit opinion. It's interesting to hear how oral argument was, but the Second Circuit, as you know, is addressing each of the reasons the plaintiffs have offered for why this falls outside Smith. And I think it's kind of interesting to look at the Second Circuit's analysis of this. It begins with the neutrality and general applicability issues, and the Second Circuit concludes that the law is neutral on its face and says it doesn't, quote, target or affirmatively prohibit religious practices, close quote. It also says that, quote, the law simply applies New York's school immunization requirements to all school children who do not qualify for the law's medical exemption. And it then goes on to say that the act of repealing the religious exemption did not in and of itself transmute the otherwise neutral law into one that targets religious beliefs. They're quoting We the Patriots. So, you know, they're for those reasons, they're saying they don't see any anti-religious bias. What are your thoughts on those rationales offered by the court?
Well, I think unfortunately, because of the circuit precedent, it was unsurprising that it came out this way. The Connecticut case was similar. There are some differences between the laws there. I think that New York's regime is a better case for the application of Fulton and avoiding Smith and rational basis, because in New York you have this discretionary regime where the physician is any physician in the state can create a medical exemption, can certify that the child may have a health objection to the vaccine, and then the school can reject that or ask for more information, at least, suggesting that there's some additional layer of discretion by the school administrators. And so I think that really cuts against New York's position that this is an objective mandatory category that's applied with real predictability in the state, and takes it out of the Fulton category. And we see this on the ground. In the complaint, there are statistics from schools that have, I think, as many as 50% of the children are not vaccinated for medical reasons. And if the exceptions being applied so arbitrarily, it suggests that there is a measure of discretion that either from physicians or schools or the state, which should allow religion to be treated on the same terms and should require the state to satisfy strict scrutiny.
Right. And it seems also that, to the point you made earlier, that, you know, when it comes to treatment of comparable secular activity, it does turn on how you define that word comparable, how you apply that word comparable. And I think what you discussed earlier, and I think what we see in some of the recent Supreme Court case law, may not be on the same page as what the Second Circuit is saying in terms of what comparable means in this context. Could you revisit that a little bit?
Well, I think there's some intuitive pull to what the Second Circuit is saying when they point out that you could have clusters of communities that have religious objections, and so the risk of infectious disease is higher when you have a lot of people who are not vaccinated. I mean, that makes sense at first blush, but the implication of that for free exercise rights is really worrying. Just because there are more people near me who practice my religion the same way, our religious objection should be weaker, or that we should be subject to greater burdens from the state's public health regime. I mean, that's just not how the Supreme Court treats religious rights. It's not how any of the COVID cases came out. The court wasn't counting the number of seats in the church. Now, some courts did do that, but the Supreme Court never endorsed such a method that said, well, if it's a really big church, then you don't have religious rights anymore in a pandemic. I think that has been discarded by Tandon versus Newsom, and if it hasn't, then the Supreme Court needs the opportunity to take the opportunity to say that explicitly.
All right, let's before we move to the cert petition, I want to talk briefly about the Second Circuit's, you know, reasoning on the hybrid rights, or the Yoder claim. And in this case, they did reject the plaintiff's comparison to Yoder, and they specifically were pointing to the limits of Yoder's holding. I think, sort of looking at it as being limited to its facts, and in so doing, they relied on the Fourth Circuit's opinion in Mahmoud, which was later overturned by the Supreme Court. Maybe can you talk a little bit about that reasoning, how significant or not significant it may have been in this decision?
Well, I think the Yoder case, if it's limited to its facts, then petitioners should still win, because they are the same group of people alleging the same kind of burden on the same religion. And so at a minimum, they should get a vacator of the Second Circuit decision for reconsideration in light of Mahmoud. And they've asked for that at the bottom of their cert petition. It wouldn't be, I think, the most satisfying outcome for critics of Smith and for practitioners in the religious liberty space if it were such a narrow result and a narrow win for these plaintiffs. But what Mahmoud did, I think, was bring Yoder to the fore, back into the fold as the seminal free exercise case that it should be, that it's not something for a particular group of people at a particular time. There is a fundamental free exercise right to direct the religious upbringing of one's children. And when the state substantially interferes with that, then we're outside of Smith. And the court in Mahmoud also resurrected or brought back to mind the Barnett case, which many people, I think, learn in First Amendment class or it's thought of as one of these landmark free speech cases, I mean, not First Amendment. And it's also a religion case that the Jehovah's Witnesses in that case were asked to say the Pledge of Allegiance and to salute the flag. And they said that was a direct coercion on them. It was a violation of their religious beliefs to affirm a pledge to the flag. And so we have now another line of doctrine to get away from Smith. And the court was emphatic on that. And so Mahmoud, of course, had these really colorful facts about what was being taught in the public schools and the parental objections, but its reasoning was not at all limited to those facts.
Yeah, but speaking of these cases, let's talk briefly about the cert petition and the questions that it raises that it's offering to the court. The cert petition presents two questions. I mean, the first is whether a law that categorically disallows religious exemptions but permits secular exemptions and other comparable secular activity violates the free exercise clause as applied to the Amish parents and schools in this case. The second question is whether Smith should be reconsidered. Let's just talk about those briefly. As to the first question, the petitioners have, identify a split that's also that they are really citing and quoting directly from a Justice Thomas dissent from a denial of cert in Dr. A versus Hochul. That dissent was joined by Justice Alito and Justice Gorsuch, and that case talks about an acknowledged split that's widespread, entrenched, and worth addressing. And so I'd just like to get your thought whether, the way that this case is coming up, and given, these words from the sitting justices, thoughts about how that plays out in the potentiality for cert to get granted.
Right. So they rely on this Dr. A dissent from denial by Justice Thomas and joined by Justices Alito and Gorsuch. And so if you have three, the question is there a fourth to address this circuit split? And the basic question of the split is, does rational basis apply to a law that exempts religious secular conduct, but not religious conduct? And Fulton seemed to answer that, but there are still more wrinkles. And so, for example, can New York rely on the fact that its secular exemption gives a benefit to the students by protecting them from whatever contraindication they might have? Or is the analysis to be focused just on the degree to which the exemption undermines the stated interest in immunization generally? And this goes much further and deeper than just vaccines. Of course, there are cases around the circuits dealing with vaccines in particular. Maybe the Dr. A case was not granted because it was tied to COVID and all of that controversy. Now with some distance, now we're talking about school vaccine regimes that have been around forever and will be around for a long time. And so maybe there's some more enduring interest in the question apart from the pandemic.
And let's visit briefly before we get to Q&A about the second question. The second question, President, just tees up straightforward whether Smith should be reconsidered. Now, it's postured in the sense of obviously the court need not reach this if it goes with the petitioners on the result they think should come from the first question. But they say essentially, if under the Smith regime, this is just going to fit neatly into rational basis review, then maybe Smith should be reconsidered. My question to you is just, what do you think the chances are that may happen? I mean, we have a number of amicus briefs already, including from some scholars and folks who are saying that that's what needs to happen. What do you think the chances are this case could be the one that happens?
I don't know about odds. I think I think that the court obviously has an appetite for revisiting Smith, and it's been searching for that replacement. And so in Fulton, you have that concurrence from Justice Barrett expressing concern that just because the law is really general doesn't mean that it doesn't work a hard burden on religious practitioners. And there's probably some good support in the history. I know that Professor Barclay filed an amicus brief on this for a higher test. And maybe it's not identical to strict scrutiny. Maybe it should be more historically grounded. But at least the concurrences in Fulton suggest the court is interested. Is this the case to do it? Well, I think it depends a little bit on whether you think the outcome here should be dictated by Fulton and Tandon. If the court will expand those exceptions, then maybe it need not reconsider Smith and should leave that for another day. Now, we, Alabama, didn't take a strong position on what should replace Smith. It seems to me that Smith has serious problems, and I think those were illustrated in the pandemic, where even if you could devise a generally applicable burden on people, that the government shouldn't be closing church without satisfying some heightened level of scrutiny. And so I think it's pretty obvious that Smith is unworkable for certain fact patterns, and we're going to find out if this is one of them.
All right, thanks, Bob. I'm going to go to some Q&A right now. We have an anonymous attendee who's asking for your thoughts about whether and how courts should weigh broader public health risks when you have a religious community that's not completely isolated, and maybe in a rural, relatively insular community, but not completely isolated. And if it says if the Amish, they may live separately, but they're not completely isolated. So I take that to be, if you're looking at the broader public health concerns, how do courts weigh that?
Well, the problem is in the status quo, they don't have to weigh it at all because of the application of rational basis. All New York has to do is say, we have a health interest in promoting vaccination. And so the particular facts of these plaintiffs and whether forcing them to vaccinate or to shutter their schools is necessary to achieve that interest is not before the court. They just can avoid the question altogether. Now, Florida filed a brief in this case in the Supreme Court, which I think goes into this in great detail. And what Florida says is if you apply some heightened scrutiny, then courts will be required to examine exactly factors like what will it take to produce herd immunity in these parts of the state? What level of vaccination? Is that different for different types of diseases? And I think the evidence is yes, that a blanket rule for all types of vaccines and immunizations is not one that's narrowly tailored to produce the herd immunity needed for the state's interest.
And thanks, Bob. I have another question from an anonymous attendee that's asking whether the Supreme Court may be concerned that any ruling in favor of petitioners could lead to more cases involving non-traditional religions and sincerely held religious beliefs.
Sorry, the question is, will the Supreme Court take more cases involving non-traditional religions?
The question is whether they would be concerned that a ruling in favor of petitioners would lead to many more cases that involve non-traditional religions and sincerely held beliefs.
I don't think so. I think the courts do have ways of testing for sincerely held religious beliefs. It's not an area that's litigated, and there may be eventually some pressure. I mean, we see, unfortunately, kind of what I think is an abuse of the free exercise clause, where plaintiffs try to achieve political objectives under the banner of religion, and we've seen that as a kind of tool of political activism from groups that don't seem to be sincere. And I have confidence that the courts will be able to sort that out, whether it will take the Supreme Court eventually developing doctrine in that area. I don't know, but I don't think it's the type of thing that that is on the forefront of the court's minds. They have a real problem with the doctrine under Smith now that needs to be resolved to protect these kinds of plaintiffs, and then I think can worry about false positives later down the line.
All right, thanks, Bob. I think we're getting close to our full hour here, and I've greatly appreciated having this discussion with you. It's been a fascinating discussion. I know we'll be watching what happens with this case, and watching with interest to see if it's a case that the court will accept. But I greatly appreciate your time. It's been a wonderful discussion.
Thank you, Judge.